जुबेर, आप अपना थोड़ा सा ब्रीफ इंट्रोडक्शन देंगे?
Yes, ma'am. I belong to Kuchaman city. It's a small town in Nagaur district of Rajasthan. And I have done my schooling from a boarding school, that's Sanskriti School, Ajmer. And I have done my bachelor's in business administration and law, 5-year integrated course from Raffles University, Neemrana, Rajasthan. And I like playing cricket and reading contemporary legal issues.
Okay. तो आज की आपने कोई न्यूज़ पढ़ी है?
No, ma'am, I did not get a chance to read the newspaper, but I read it last night on the electronic news portals. So I think I'm quite aware of the legal.
कोई लीगल न्यूज़ बताने के लिए आपके पास?
Legal news recently, it's not of a day or two, but it has been around 3-4 days. The Supreme Court has recently upheld the constitutional validity of the Prevention of Money Laundering Act 2002 in the case of Vijay Madan Lal Chaudhary versus Union of India. So that's quite legal news in doing rounds right now.
On what grounds the constitutionality was challenged?
Sir, constitutional validity, there were several provisions of PMLA which provided for the non-supplying of the copy of ECIR, the investigation done by the directors of ED. So I do not remember the exact provisions, but the Supreme Court in this case held that ECIR, that's Enforcement Case Information Report, that is lodged by the ED, is not equivalent to FIR. But the procedures of CRPC must be followed by the directors of ED while conducting the investigation. Then there was a separate provision of Section 45 of PMLA that provides for twin conditions for seeking bail under the arrest made by the ED. So in this case, there are twin conditions. That one condition is that the person seeking bail must prove it before the court that.
All right, thank you.
अच्छा जुबेर, why you wants to become a judge? कब सोचा आपने ऐसा कि आपको जज बनना है?
Ma'am, I decided it way back in my law school when I used to intern in the courts. And the primary reason for becoming, I want to become a judge is that I want to serve the society and do justice in a very routine manner and make difference to the lives of people.
अच्छा, जब आपने अपने BA, BBA, LLB में जब आपने एडमिशन लिया था, तभी आपने सोचा था कि मैं कुछ जज बनना है इसलिए LLB करना है, या आपने लॉ प्रीलिम आपने ज्वाइन कर लिया था बस?
No, ma'am. I did not decide it at the very beginning, but when I entered into my law school and I got an opportunity to intern at different courts across the country and even in the law firms as well. So there I decided to become a judicial officer and choose a particular career path.
Okay. Yes, Crpc.
Just I wanted to ask, you just mentioned that I wanted to secure justice.
Yes, sir.
I just wanted to ask a simple question that how I'm going to do it better than the others.
Sir, basically, I have never been into practice. And I think when I'll enter into the services and I'll be trained accordingly, and that time I will be able to answer this question, sir, because I have never been into
practice. It a good thing that you have never been into practice? Is it a positive thing?
Sir, indeed, in my case, sir, I think it's a positive case because I was not able to manage. Like when I passed from my law school, I did try to join litigation, but I could not manage the preparation of judicial services as well as litigation simultaneously.
What are the qualifications or the essentials of becoming a judge of the Supreme Court, Zubair?
Sir, Article 124 of the Constitution of India provides for it. The first thing is that he must be a citizen of India. He must have been a judge for 5 years across in any of the high courts across the country, and he should have been in practice for 10 years as an advocate in the high courts, and he should, in the opinion of president, he should be an eminent jurist. So if he fulfills either of those conditions, he can be appointed.
Is there any eminent jurist that has been a judge of Supreme Court of India?
Sir, to my knowledge, there have been no person who has been appointed as an eminent jurist in the Supreme Court.
How many number of amendments we have done so far in Indian Constitution?
105 amendments we have.
And which were, I mean, what is the last amendment?
Basically, ma'am, initially there was a 102nd amendment, 103rd. I am not able to recall the exact amendment number, which provided that the SEBCs across the country would be determined by the president and not the states. So, in the 105th amendment, the power was restored to the states to determine the social and educational backward classes. Following the judgment of DY, there was a judgment of Maratha Court case. So after that.
Okay. Okay. Do you know, I mean, obviously you must know what is preamble. You know preamble?
Yes, ma'am.
How it starts?
Yes, ma'am. We, the people of India, having solemnly resolved to constitute India.
Why we have
into
used the term "we, the people of India"?
Because, ma'am, in our Indian constitution, the people of the country are sovereign, and so that's why we start with the people. So it's a democratic nation. It's to the people, for the people.
What is the source of this constitution?
So the people itself, sir. The people are the sovereign, and source of the constitution is, sir, the Government of India Act was there in 1935, and following
Are
which
you sure the Government of India Act is the source of this Indian constitution?
So not exactly, but yeah. So there was Constituent Assembly, and there were debates upon it, Constitutional Assembly debates, and then ultimately the constitution came into existence. So,
Is we the people not the source of this constitution?
so I'm not able to exactly like throw a light upon the exact source of constitution.
So the constitution derives its power from what?
People of India, sir.
So should not it be the source of the constitution?
Yes, sir. In a way, it is. They are people of the source. That's what I told in the beginning, sir. I'm not exactly sure about it. But yes, the constitution derives its power from the people of India.
So tell me, what is justice in your opinion?
Justice is, ma'am, like protecting the rights of people which are guaranteed to them under different statutes. So whenever the rights of people are infringed in one or the other way, they can approach the court for protection of their rights.
Okay.
Only the courts? If someone goes to a tribunal or an arbitrator, will there not be justice there?
So they are also a kind of performing the quasi-judicial functions. So yes, they're quasi-judicial functions, tribunals, and so yes, they can also be considered as a court.
They can also be considered, or I mean, they provide justice. So if there is an issue with respect to environment and someone goes to the National Green Tribunal, I mean, is it something that needs to be considered, or do they secure justice for citizens of India?
So they do secure justice, because when these bodies act judicially, sir, they can definitely be called as the courts of justice.
What is the difference between a tribunal and a court?
I'm really sorry, sir. There is some. Your voice was breaking. Pardon me, sir. Can please repeat your question?
I'm saying, what is the difference between a court and a tribunal?
So court, sir, a tribunal also courts exclusively perform the judicial functions. Tribunal, on the other hand, and it is presided over by the judicial officers. Secondly, sir, tribunals perform the quasi-judicial functions, and they simultaneously perform judicial as well as administrative functions, and they are primarily presided over by the executive office.
What is this quasi-judicial, Zubair?
Sir, quasi-judicial means, sir, not completely judicial body. It performs judicial as well as the administrative functions, sir. So, and they're presided over by the executive officers generally.
Can you tell me any quasi-judicial proceeding?
Yes, ma'am. If we look at the very basic level of subdivisional magistrates, SDMs, which we have at block levels, they perform the administrative functions, as well as under CRPC sections 107 and 107, 108, 109 process. They also perform a judicial function under 145 of CRPC. So they are the quasi-judicial bodies.
we have any provision which is, which is the one with the, which called the quasi judicial proceeding? Any provision,
Which defines quasi judicial proceedings?
No, not defined. Any provision which, जिसकी proceeding quasi judicial proceeding की तरह होती है.
Ma'am, 145 CRPC. That's quasi judicial
125
proceeding.
125 CRPC?
Yes, ma'am. Because that's partly the adjudicating the rights between this part, adjudicating the rights, civil rights of the part.
अच्छा एक बात बताइए, अगर 125 CRPC talking about the maintenance of a woman, अगर मान लीजिए कोर्ट ने वो मेंटेनेंस ग्रांट नहीं किया, एप्लीकेशन गॉट डिसमिस्ड, तो क्या हम सेकंड एप्लीकेशन दे सकते हैं मेंटेनेंस की?
I think it's appealable.
It's
so
appealable.
If any,
but that is not appealable. It can be go in the revision. It is not.
Yeah, exactly. Revision. Sorry.
Moreover, that amounts to dismissal, and it is not amounting to conviction or the acquittal. So the bar of 300 will not apply upon. Fine.
Okay, I'll take a note of it.
Yeah. Okay, tell me, if the divorce has been granted on mutual, if there is a mutual divorce between husband and wife, right? Can still divorced wife claim maintenance under section 125?
No, ma'am. There's a bar on it when the parties, the husband and wife, mutually enters into a divorce, and they cannot see, the wife cannot seek maintenance.
Where it is mentioned?
It's 128, 127 of CRPC. I'm not exactly recall the exact.
125 clause 5. Read once. 125
yes.
clause 5. It talks
exact
about,
provision. I don't know.
It talks about the separation. Yes.
Just a pretty simple question.
Supposedly,
yes, there is no subsistence of marital relationship between former spouses right now, meaning thereby the marriage has come to an end. So why should a husband take the liability of a wife through maintenance?
Pardon me, sir. Can you please explain it?
I'm just saying that the marriage has come to an end.
Yes, sir.
And now, the wife has filed for maintenance. And the court has granted maintenance to the wife, to the former wife. Why should the former husband, take the responsibility of the wife right now when there is no subsistence of marital relationship between the two?
Sir, if we look at the main reason behind the 125 of CRPC, there is the maintenance is granted in the cases where the wife is unable to maintain herself. So, sir, even if the marriage comes to an end and the wife is not economically or independent, and if she's unable to maintain herself, then she will be subjected to undue hardship for a period of time. So, in order to prevent the undue hardship that may be caused to women, I think she is entitled to the maintenance even after.
But the husband has no rights right now with respect to any relationship with the wife. Why he should be duty bound?
Sir, he is duty bound because, sir, there's no here the rights of only husband is not only on stake, sir. Even there are two individual persons and the rights of both the persons are at stake. So just because for upholding the rights of husband, because the marriage has come to an end and he should not be liable for anything, the another person who was in marital relationship cannot be subjected to any hardship. So there has to be a balance. So justice is not delivered.
The layman would ask, why should I bear the burden of a former relationship? I have no relationship with that particular person.
So there is a concept, sir, because it will definitely inhuman act on the part of the husband if he escape from the liability. Yes, definitely, sir. If somebody is she is unable to maintain herself when she was in a marital relationship, and then a husband on one fine day decides that I don't want to be in this relationship. So there has to be some sort of maintenance of the wife, and even to discourage the practices of the women, to exploitation of the women, sir, because
what is
in
this
this way,
inhuman, Zubair? Where it is defined, inhuman?
so I'm not aware of the exact provisions of where it is defined, but inhuman means something that is which does not secure the dignity of life to a person, sir. So if somebody, if women are left at this peril, like where the husband on one point decides that he wants to get out of the relationship and get out of entire liability, sir, then I think it will be unfair, or it will not be a justice to the women who's unable to maintain herself, who is not economically independent, sir. So
Can
for
a
that
Muslim
reason,
women,
I think.
can a Muslim wife claim maintenance under 125 CRPC?
Yes, ma'am. Yes, ma'am. Definitely, she can claim
Do
it.
you know the
It was held
landmark
in the landmark.
judgments? Yes, tell
Yes,
me.
ma'am. It's Mohammad Ahmad Khan versus Shahbano Begum. It was a landmark case in which it was held.
And after that, for Muslim wives, there is a law that protection of right on divorce. It's about 1986 Act, where the
Yes, ma'am.
Muslim women get protection under that particular law statute. Then
Yes, ma'am.
why they get maintenance here in 125 CRPC? That
But
act specifically talking about the maintenance there itself. Then why they are again asked for maintenance on a 125 CRPC?
ma'am, I think the reason is that in the Muslim Women Protection Act, there is a provision of, I'm not exactly aware about it, but there's a provision of some lump sum payment which may be paid by the husband to the wife. And in contrast, in 125 of CRPC, there is a payment, there's a provision for payment of monthly allowances. But that can be set off as per section 127 of CRPC if wife has received the lump sum payment.
Okay. Moreover, 125 is a secular provision.
Yes, exactly. Yeah, that's the main reason.
Yes, tell me something about what is the difference between section 300 and article 20 clause 2 Constitution of India.
Yes, ma'am. So Article 20 clause 2 basically just provides for where a person has been prosecuted and punished for an offense, then he cannot be again prosecuted and punished for the same offense. So it basically provides for the conviction part, whereas in the section 300 of CRPC, it provides for the acquittal as well as the conviction, where a person has been acquitted or convicted after a trial on the same set of facts, then he cannot be prosecuted again. So it's a concept of double jeopardy, which is provided under both.
And what maxim section 300 tells us CRPC? What maxim section 300 CRPC based?
Ma'am, it's authorized acquit and authorized convict. So these are the maxims.
Okay, we have provisions that all the evidences should be recorded in the presence of both the parties in trial, right?
In the criminal trials.
In criminal trial, yes. Do we have any provision which talks about that evidence can be recorded in the absence of the accused in CRPC?
Yes, ma'am. We have a section 299 of CRPC, which provides that where the accused is absconded or is not, his presence cannot be secured before the court by any means, then in that case, the court can proceed to record the prosecution evidence. And if the accused again does not appear or the witness cannot be called at the later stage of the case, then those evidence recorded can be used in the case.
Okay. How many type of trials is there in CRPC given?
First is trial before the Court of Sessions. Then we have trial of warrant cases instituted upon a police report and instituted upon a complaint. Then we have summon case trial, and then we have summary trial.
Can you tell me something about summary trials?
Yes, ma'am. Summary trial. Am I audible?
Yes, you are audible and visible both.
Yes. So summary trial is basically provides that there are in the cases where the offense is punishable with less than 2 years imprisonment, and it can be conducted by the Chief Judicial Magistrate, the Metropolitan Magistrate, the Magistrate of First Class with the permission of the High Court. Even the Second Class Magistrate can do so. And the punishment of not more than 3 months can be passed while trying any offense as a summary trial. In a summary trial.
What is the difference between compounding of offense and plea bargaining?
Compounding of offenses basically is restricted to section 320 of CRPC. So any offense which is made compoundable under 320 of CRPC, that can only be compounded. In contrast, plea bargaining allows to compound any offense which is punishable up to the imprisonment of 7 years. And even if it is not mentioned under 320 of CRPC, we can bargain, the person can bargain the sentence in the plea bargaining concept. Under compounding of offense, the effect is of acquittal. But in the plea bargaining, the effect is not of acquittal. The accused may still be subjected to some sort of punishment. Maybe it may be some reduced punishment, but he will definitely be subjected to some punishment.
Who asked for plea bargaining?
The accused asked for that.
And who asked for compounding?
Both the parties. Both the parties, if they enter into, they settle the dispute amongst themselves, then they can move an application before the court for compounding.
Person is mentioned in the column in 320 itself. Just go through with that.
Okay. But ma'am, generally, I think in compounding, there will be both the parties have to agree. Basically, a victim. It's a victim who must agree to compound.
Yes, it's victim and you can say prosecution. Garvit sir, I'm passing you to you.
Yeah, just a simple question.
Yes,
where the Evidence Act says the Evidence Act applies to the whole of India and applies to all judicial proceedings in or before any court.
Yes.
Can you please explain me in or before any court? Is there a difference between these two terms, in a court or before a court?
Can I just take a few seconds to think about it?
Yeah, sure.
I'm really sorry, sir. Not exactly about. Okay, let me ask you something else. You know about discharge of agreement?
Discharge of agreement. Yes, sir.
Discharge of agreement, discharge of contract, all these things.
Yes,
I'm going to ask you something with respect to discharge. There are two things with respect to discharge of agreement by the parties themselves: accord and satisfaction and waiver. There can be discharge by mutual agreement by way of waiver, and there can be discharge by way of accord and satisfaction.
Yes, sir.
What is the difference between these two things?
Sir, waiver is that where the party like who is seeking the performance of a contract can waive with its performance. It can do so by not compelling the other party to perform the contract. That's complete waiver. He does not want to get it performed. Secondly, in case of accord and satisfaction, the other party can like suppose for example there is certain things, 100 tons of coal has to be supplied under a contract. So the other party can get into an accord and satisfaction of the contract by just receiving 50 tons of coal, and then it can consider it as a complete compliance of the conditions of the.
They have waived 50 tons of coal. Is it not waiver then? They have waived the performance of 50 tons of coal. Is it not waiver then?
To my understanding, sir, waiver is the complete absolving the other party from the entire performance of the contract.
So partial performance will be waiver or accord and satisfaction?
Sir, to my understanding, it would be accord and satisfaction, sir, not the.
And what about substituted performance? What would it be?
Substituted performance is the exact performance of contract by any other party, not the particular person who is under obligation to perform it. So it is provided under Section 20 of Specific Relief Act. So if the party can get it, the other party can get it performed through any third independent agency or by itself, and can recover the cost of the performance from the person who was obligated to perform the particular act.
All right. What do you understand by hypothecation, Zubair?
In a hypothecation, the particular so in hypothecation, the possession of the property is not transferred, but it's basically a kind of pledge. So
what is the difference between pledge and hypothecation?
So in pledge, there is a transfer of the possession of the property. So in every pledge we have a bailment, but in hypothecation the property itself is not transferred, but a right of the party is created upon it. In case of, suppose in the it basically takes place.
I'm confused. You said earlier in hypothecation, sir, the possession is not transferred. Now you're saying pledge is different, and
yes, sir,
pledge,
what different?
Possession is transferred. I'm confused now.
Yes, sir. So in pledge, what happens is that there's a bailment of a property. That means a property is given to another person for a particular purpose or for discharge of any debts. So the property itself is transferred, and in case of hypothecation, there is an obligation created upon the property.
Wait for a second. The property itself is transferred. Can you please explain the statement, Zubair?
So the possession of property is given, not the ownership rights over the property.
So if we can actually use these two sentences in the alternative, that the property is transferred means exactly.
No, yes, sir, that's not the ownership right transfer. Hypothecation generally takes place in the vehicle loans cases, sir, where the finance company has a charge over the vehicle financed, but the possession of the property remains with the owner.
What is not transferred in hypothecation and transferred in pledge?
So the possession of property.
It is not transferred in hypothecation and transferred in pledge.
Yes, sir.
Okay, thank you.
Chali, it was great, Zubair.
Thank you.